So first of all, good evening everybody and welcome. For those of you on the screen, we've got a fantastically full audience here tonight. So welcome to this panel discussion on the role of whistleblowing in detecting and preventing corruption. And we meet today on a very sombre evening when our focus on tackling corruption at home has to be overshadowed by the events in the Ukraine today. And that explains why we had hoped to have both Margaret Hodge and John Penrose with us in person, but there's obviously been a very important debate that they've had to attend in the House this evening. But we're delighted to welcome you both today. I should have introduced myself. I'm Liz Gardner. I'm the Chief Executive of Protect, the UK's whistleblowing charity, and we've been delighted to team up with Leigh to bring you this event this evening. In a moment, I'll just set the scene a little bit about whistleblowing and corruption, but I'll introduce you first to our panel, each of whom is going to speak to you for about 5 minutes, and then we hope to have some time at the end for some questions. So John Penrose is a Conservative MP for Weston-super-Mare. He's a former minister and the government's independent anti-corruption champion, a role he's held since 2017, and which he both supports and challenges the government on corruption. And he's also chair of the Conservative Policy Forum. So you're very welcome, John, today. And Dame Margaret Hodge, many of you will know, is Labour MP for Barking, former minister, former chair of the Public Accounts Committee, and currently chairs the all-party parliamentary group on anti-corruption and responsible taxation. She's a stalwart campaigner against corruption and very much in support of whistleblowing. We're also joined online today by Jonathan Taylor, a whistleblower himself who exposed a major bribery scandal in the oil industry, and he's going to be talking to you about the personal experience and the retaliation that whistleblowers can face, in his case over many years and across continents. And then we'll hear from Paul Dowling, a specialist international human rights lawyer here and a partner here at Leigh. Paul successfully represented Amjad Rehan, who was a former partner at Ernst & Young, and he blew the whistle on money laundering and conflict minerals concerns in the United Arab Emirates. Amjad was eventually awarded over £8 million in damages, and his case broke some new ground in whistleblowing protection, so we look forward to hearing that too. And last but not least, we have our own Andy Pepper-Parsons, who's head of policy at Protect, and he's going to focus on how the legal framework might be improved to ensure that whistleblowing concerns about corruption are heard and addressed with less risk to those individuals who speak up. But just before we go to the panel, I just want to briefly set the scene, because Protect, we start from the position that whistleblowers provide a vital function in detecting and preventing corruption. Time after time, whistleblowers are going to be the first to identify and to speak up about corrupt practices, whether it's to their employer, to a regulator, to law enforcement bodies, or to the press. It's estimated that 43% of fraud is detected by tip-offs, and 50% of that comes from whistleblowers. So given the vital service that whistleblowers could be providing in organisations and holding both organisations and governments to account, the question is this: why are so many ignored and retaliated against? Why do so many have to go to the press to have their concerns taken seriously? And what can we all do to get employers, regulators, law enforcement agencies and the government to see whistleblowers as an asset in the fight against corruption? And I don't need to tell any of you here that corruption and economic crime is big business. It's rarely out of the news, as we've seen from headlines this week about the Credit Suisse failures to prevent corruption, revealed by an anonymous whistleblower. And that's not unusual. Wherever you see these public scandals, the chances are high there are whistleblowers involved, often ignored, sometimes harmed by their attempts to speak up, and often after the event also calling out that culture that prevented them from speaking up or being listened to. Last month, Spotlight on Corruption produced a report which sets out the mind-boggling figures. Corruption costs the UK economy an estimated £290 billion. That's equal to 14.5% of our GDP. The Treasury Select Committee this month noted an upward trend in the economic crimes of bribery, corruption, fraud, tax evasion and money laundering. Transparency International UK reported that over 2,000 companies registered in the UK have been linked with 48 money laundering and corruption cases involving Russia. Now, some of those may be sham companies just set up for the purposes of corruption, but surely some of those companies where corruption occurring, somebody has seen the wrongdoing. Are they too scared to speak up? Have they spoken up to the wrong person, or have they spoken up only to be ignored? What's going wrong? But corruption isn't just about the big business and the money laundering. It happens across all sectors. 8.5 million was lost to charities last year through fraud. And as we saw at Protect during the COVID crisis, it also affects small businesses. We saw an unprecedented rise in concerns about fraud on our advice line last year when furlough leave was introduced. Employers were claiming the furlough money, but requiring their staff to come and work anyway. And many of those workers wanted to whistleblow about what they knew was wrongdoing. Now, HMRC says around 30,000 people contacted them about the various schemes that were put in place to help during this coronavirus. But still, 8% of coronavirus job retention scheme payments were lost to fraud and error. Could more effective whistleblowing arrangements have reduced those losses? Well, there's some good news, and that's that the government has an anti-corruption strategy. And one of the key goals, and I quote, is a more open government that is trusted by citizens with robust protections for whistleblowers. And yet, as we come to the end of the strategy period, two of the key whistleblowing goals, including a review of the whistleblowing framework here in the UK, are off track. And I quote, serious risk to delivery. Put bluntly, whistleblowing reform is overdue, and those robust protections are yet to emerge. In too many sectors, there are no whistleblowing channels, no independent places where individuals can go outside of line management. And that safety valve of whistleblowing is just not present, and that needs fixing. Whistleblowers have two fears. They fear that they'll be retaliated against for speaking up, and they fear that nothing will happen if they do. So what do we need to do to improve the response that they get from their employers, from regulators and from enforcement agencies? Because there is, in a simple, cheap way to detect and deter corruption, and it lies with workers inside organisations. So what do we need to do to get the government to take whistleblowing more seriously as part of the solution? And on that note, I'm going to turn to our first speaker, anti-corruption champion John Penrose, who I hope can update us on the strategy and how you think the role of whistleblowing in detecting and preventing fraud might be strengthened. Over to you, John. Thank you.
Well, thank you very much, and thank you to Leigh and to everybody involved in organising this event today. Really pleased to hold it. I mean, I appreciate, as you say, that it's happening at a moment when we might be overshadowed by terrible events happening in Ukraine, and those matter obviously. But this is something which, while not quite as immediately urgent today, is really, really important, and your introduction just now ably laid it out. So I'd start by saying you are absolutely right to say that whistleblowing is not just vital, it's also really effective if it's done right. And we are miles off the pace from where we ought to be. You're right to point out the anti-corruption strategy updates, which we publish every year. I'm insisting that if we're going to publish an anti-corruption strategy update, we need to walk the talk, which means it's got to be properly transparent, and that means being honest when we're off track. And this is one of the areas where we are. And so you're also right to point out that my role involves both support and challenge. And so I hope everyone will understand, given the fact that we're off track in this area, if what I'm about to say is rather heavier on the challenge than perhaps on the support, because we have to up our game, and we have to up it quite significantly. I think it's worthwhile pointing out that 10 plus years ago, Britain's whistleblowing framework was regarded as pretty cutting edge, and we were pretty good. But the world has moved on, criminals and crime have moved on. You just explained, and rightly so, that broadly speaking, the old-fashioned business of breaking into bank vaults and making off with bars of gold or anything like it is an old man's crime now. Most crime has migrated online, and online fraud and scams is the vast growing criminal industry at the moment. And therefore, having good whistleblowing practice and also applying it properly right the way across the economy. So it isn't just having the right legal framework, it's also making sure that it's being properly implemented in all the necessary sectors is essential, not least because, as you said, and I would agree, it works. I mean, it's incredibly effective, and it's cost effective too. It is a force multiplier for anything which the police or the National Crime Agency or the Secret Fraud Office can possibly do. and it just basically massively improves and increases their range, their scope, and their penetration as well. So what do I think we need to do? Well, there is a series of things. There are existing framework, I think, is now being left behind by the way the world is today, and we need to therefore look at upgrading it. There's a new version of the strategy which is due to be being developed, anti-corruption strategy being developed in the course of the coming year, and I hope that will include some commitments to cover some of the areas which I'm going to be mentioning in a minute. But also, there's a crucial point about just implementing what we've already got much more effectively, much more thoroughly, and making sure that where there are not adequate whistleblowing opportunities in individual sectors, that things happen rather than everyone just standing around and wringing their hands. Let me talk about some of the shortcomings, if I can, as a way of sort of getting the conversation going. The first one is the who counts as a protected person. At the moment, we tend to focus mainly on staff, but there's a whole range of other people who may come into contact with wrongdoing in any organisation, be it private sector, for-profit, be it not-for-profit, be it public sector. And those include suppliers, they also include some customers, they certainly include non-executive directors and many other classes of people. They need to be covered and protected where necessary so that they can whistleblow if necessary. We also need to be a bit more accurate about what we count as a qualifying disclosure, what kind of whistleblowing, if I stand up and do it, will earn me those protections and will make me know that I'm going to be protected, and that needs to be visible up front because it requires a huge amount of bravery to be a whistleblower. And you need to know not only that you're going to be properly protected, but also that the juice is worth the squeeze, that the chances of something happening to stop the thing that you've seen happening again is likely to come about. And those two things are equally vital. Thirdly, we need to, I think, deal with, I think you mentioned, the likelihood of retaliation. This is often not just a legal point, it's often also a cultural point, because particularly in more established firms and organizations, but also in more established professional cultures, it is all too common, quite apart from whatever the legal process may be, for everybody to close ranks on somebody who has stepped out of line or has threatened other people who are perhaps senior than them in an organisation. So it's partly legal, but an awful lot of that is about leadership and about organisational culture, be it private sector, be it public sector, be it third sector as well. But equally, I guess the final point is there's a whole series of legal points which I will defer to Leigh and others about to make sure that, for example, non-disclosure agreements don't apply when it comes to whistleblowing, and that people don't feel that they can be monstered or stopped if they are needing to blow the whistle, that their contractual terms or non-disclosure agreements don't apply. So there's just a quick summary. I'm conscious that you rightly only wanted me to speak for 5 minutes because we need to allow time for both my other fellow panel members, but also for questions and comments from what I'm sure is an incredibly educated and astute audience. So I'll stop there, other than to say I'm looking forward to hearing what everybody else has to say, but I hope that has at least got everybody's juices flowing for the rest of the hour.
Thank you very much. That's a really good start for the debate, and some really positive comments there in terms of things that we would absolutely support you on, shared aims in terms of some of the changes that we need. Do you think we need legislation sooner rather than later? We've been hearing today about the economic crime bill. Do you think there's an opportunity there to sort of boost whistleblowing along the way?
It's a possibility. I suspect probably, I think the economic crime bill fully fledged is going to be quite a big bill already, and there's all sorts of really important things in it, like reforms to Companies House, which, sure, given what's happening in Ukraine, everyone will understand is sort of critical and urgent now. So it's possible, but it may also be a bill that's very large already. I'm not sure I haven't seen the sort of completed draft of it yet, so I don't know. But if it isn't, then my response, I think, would be, firstly, we need to get on with implementing what we've already got, because there are too many sectors where even what we've got at the moment isn't being properly applied, and we can make a lot of progress without legislation just in doing that properly, and demanding proper leadership and proper culture change programs and properly communicated whistleblowing channels in organisations up and down the country. But in due course, yes, we are going to need more powers and changes to those legal frameworks that I've just described. We'll have to tie ministers' feet to the floor in order to get them to make firm commitments about precisely which of some of those ideas that I've just been suggesting they're willing to sign up to. But I hope at least it's given people a shopping list to begin with.
Thank you very much, John. That's really helpful. So those of you many of you here will have read about Jonathan's story and his background. But Jonathan blew the whistle in 2013 on a multi-million international network of bribes paid by the Monaco-based Dutch oil company SBM Offshore. And his evidence to the Serious Fraud Office and other enforcement bodies around the world has resulted in fines of millions of pounds to SBM Offshore and the imprisonment, indeed, of some senior staff. Jonathan left SBM, but the repercussions personally have continued. His former employer has tried, unsuccessfully, to bring a claim of defamation against him. And back in July 2020, he was arrested whilst on a family holiday in Croatia as a result of an Interpol red notice seeking his extradition to Monaco to answer charges that were initiated as retaliation against him by his former employer. Now, Jonathan's had to fight his case through the Croatian courts, and it was almost a year before he was allowed home, although I think the case is still not yet closed. But his case and that of Amjad Rihan that we're going to hear about shortly are very extreme cases of whistleblowing, but the follow-up treatment that he's experienced may indeed have a chilling effect on others who are thinking of coming forward to reveal corruption. So, Jonathan, we're going to ask you just to give us a little bit of a flavour of the experience that you've had after revealing corruption and the support, or maybe the lack of it, from the agencies that you've helped with the investigations.
I'll give it a go. So, if you were to gauge the success of whistleblowing in terms of the results, the effect of the whistleblowing, then I guess I did quite well in terms of 5 different prosecutors fining my former employer over $850 million. One of its former CEOs was in prison for 3 years, another was fined €500,000, and various imprisonments of other salesmen at my former company have also followed. I was responsible for the wholesale resignation of what used to be by market capitalization, the biggest company in the Southern Hemisphere, Petrobras. That's the national oil and gas company of Brazil. I probably contributed to the downfall of Dilma Rousseff, who was very much involved in the whole scandal as a former energy minister, and then chairperson of Petrobras, and then the president of Brazil, who ultimately was impeached. Likewise, various kleptocrats in Angola have been identified, and now they're being pursued through the Portuguese courts. So all in all, I like to think that I have something to show for my whistleblowing, and certainly the company could never claim that it got away with it as much as it tried to cover up its corruption. I didn't hold back in making sure that their corruption was brought to justice. But if, however, you measure and gauge whistleblowing by the results to the individual, then I couldn't really have done much worse. Any potential corporates I'm talking about, whenever I refer to whistleblower, of course, talk about corporate whistleblowers. I'm not talking about the Catherine Guns and the Ed Snowdens of this world. But anyone that knows or has seen what's happened to me, I fear very much that what's going on with me will cause potential whistleblowers in the future to back off. The results could not really have been much more devastating for me. The tip of the iceberg was 2015, when a SLAP, which is an acronym, stands for Strategic Lawsuit Against Public Participation, was issued against me, trying to silence me, trying to ruin me financially, and so I wouldn't be able to defend the suit, and have my former employer procure a statement from me saying that all I had said was totally untrue, seeking an injunction against me from ever speaking again, through fear of being fined €10,000 per day for so long as the injunction was breached, as if you could unbreach it. They were seeking damages of €630,000 from me. They got an ex parte garnishee injunction against my house and my bank accounts. Fortunately, I found a fine lawyer that's acted for me on a partially pro bono basis, and we filed an extremely good defence, 140 exhibits, and SBM used this Dutch, this is where the proceedings were commenced, Dutch legal tool called a nihil application, which had the effect of reducing their claim against me to zero, and causing the court, as a reaction to that, to withdraw the case. So I never had my day in court. I was never able to defend the defamation proceedings publicly. And of course, the costs aren't awarded in the Dutch court. So what costs I did have to pay, it wasn't entirely pro bono, I had to pay. So they got away pretty much scot-free from trying to ruin me financially and probably mentally too. Yes, it did have that chilling effect, which was intended, of course, for a few weeks. But fortunately, again, I found a fantastic Dutch lawyer who was able to represent me and did a fine job. Otto Volgenant is his name. But that, as it turned out to be the tip of the iceberg. Now I sit here. My whistleblowing has cost me a year of my life. It has cost me my marriage. It has cost me my career. No one, I was a lawyer in the oil and gas industry. No one in the oil and gas industry will employ a lawyer who's been a whistleblower. It's cost me a year of my life. The effects could not really have been much more dramatic upon me, and it spells out to the world how ill-equipped the world is for whistleblowers like me. Now, I could just go away and be utterly miserable for the rest of my life as a result of being a whistleblower, wondering what's going to happen next. I'm at my lowest point of my life right now. What I like and what I pray and what I hope will come of this is that people will see what happened to Taylor. And if they're going to pass legislation to support whistleblowers, let them make sure the legislation passes the Taylor test. Because without that, it's not good enough. The world is not ready for whistleblowers yet. That is so profoundly obvious. I'm still being chased by the state of Monaco, persecuted for a frivolous and vexatious a charge, which I'm being told apparently next week whether it's going to be dropped after this is the whole reason that a red notice was issued against me in Monaco. In Croatia. That's still, the story is still continuing. It still has not come to an end. But again, I don't want to feel that all my time has been wasted, other than, of course, making sure I did bring corruption to justice when it came to SBM. I would implore that lawmakers, if they don't already know my case, look at my case, look what happened to me, and pass legislation that seeks to protect people like me. Otherwise, we're not going in the right direction. And as I said, the world is not equipped for whistleblowers at the moment. That's my 5 minutes for now. This is the first time I've met Dame Margaret Hodge to the extent we're meeting at all. And can I just please send out my heartfelt thanks to you, Margaret, for all the help and assistance you levied for me when I was in that shocking year of exile in Croatia, being pursued. Thank you so very much. That's all from me for now.
Thank you, Jonathan. That was incredibly moving and powerful speech about both the incredible corruption that you revealed and the incredible impact it's had on you. I think it's going to be quite hard, but we've got the right person to follow that. We're very pleased that we can welcome back Dame Margaret Hodge. And as Jonathan said, she's been an absolute star in terms of raising Jonathan's case in Parliament all that year he was in Croatia. So pleased to welcome you back again, Dame Margaret, and the floor is yours for the next few minutes.
Yeah, sincere apologies, and thank goodness I could come back. And I did hear most of that, Jonathan. And I was hoping that the one thing I was hoping tonight was to meet you in person. So I'm sorry we haven't done that, and perhaps we can do that on another occasion. And I salute you for your bravery, and I thought that was a very emotional and difficult speech you made. I congratulate you on doing that tonight. I'm so sorry, John, that I missed also the last part of your speech. So apologies to everybody if this repeats some of the things that John said. My real respect for whistleblowers sort of flourished when I became chair of the Public Accounts Committee, because a huge amount of the work that we did in trying to hold government to account for our money, spending our money, and the work that I started doing there, which I've carried on around tax avoidance, tax evasion, which has moved across the spectrum now into corruption. A lot of that work was facilitated by the bravery of individual whistleblowers. And I think there are a couple of lessons I learned from that. Was from 2010 to 2015 when I was doing that job. One of the things was that Jonathan talked about respect for whistleblowers. I think what shocked me hugely was the way that those organizations where there was a whistleblower responded to it. And I'm going to take two examples. One was PricewaterhouseCoopers, where we had a big tranche of leaked documents which demonstrated that they were sort of into an industrial marketing of a tax avoidance scheme in Luxembourg. And the other was HSBC and the Swiss branch of HSBC, where again a whistleblower revealed through documents that that particular branch of HSBC was involved in, at the best, tax avoidance, in my view, tax evasion, supporting their clients in tax evasion in the way that they use their money in Switzerland and then spread it across the world. And what shocked me from both two prestigious organizations, PricewaterhouseCoopers, for whom I had worked for a couple of years before I became an MP, and HSBC, with whom I bank, was that they treated the whistleblowers as thieves. That there was no acceptance of the importance of the information that was revealed by the whistleblowers, and that there was a fury that they were thieves. And in fact, they pursued them, Jonathan, very much in the way that they pursued you, trying to get them imprisoned, and succeeding in one case for a little while, imprisoned for the work they had done in revealing documents. They had, in the view of the organization, they'd stolen them. And we just couldn't have done all our work in the Public Accounts Committee without the support of whistleblowers. So I think they are central. That's the first thing I want to say. The second thing I want to say is that the title of this is the first line of defense. And I don't want whistleblowers to be the first line of defense. And this is where I hope John and I can work together in Parliament. And this is where all these reforms that to tackle the corruption that has made the UK a jurisdiction of choice for too much corrupt activity is so important. And I put it into four categories. The first is we need much, much better transparency, hence moves like the one of having a public register of beneficial ownership of properties owned from abroad. We need much tougher regulation, hence, for example, the support of Companies House, which we've been waiting for so long. We need much stronger enforcement, and I'll come back to that, even where the agencies have powers to pursue corruption, they fail to do so either because of lack of resources or because of a reluctance to use the law actually to pursue bad behavior. And the final thing is public accountability. And I would put in that as well, the accountability of all those people working in the financial services sector and particularly in London, whether it's lawyers, whether it's banks, whether it's accountants, whether it's advisor, who at the best collude, at the worst facilitate a fraudulent activity. And Liz, you talked at the beginning about Credit Suisse. It isn't just that they ignored it. I think in that particular tranche of leaks, they facilitated it. So I would not put, I would put whistleblowing as an important line of defense, but I think there's a huge amount of action that we need to take around transparency, regulation, enforcement, and accountability, of which I've only just given examples, which would help us ensure that we don't need whistleblowers quite so much. That's the first thing. The second thing is my frustrating experience that whenever I do get information from a whistleblower and I do give it to a government agency, it just seems to fall down a big black hole and I never hear anything again. And even when I pursue the issue with the relevant government agency, I never get a satisfactory answer back as to whether the matter was properly investigated on the back of the whistleblower's information or whether it ever led to activity. And I've got a current case of somebody who wrote to me about a real fraudulent claim around the furlough scheme, where I've written, I've rewritten, I've met HMRC, and I still haven't got an answer as to why there hasn't been action taken, or whether in fact the whistleblower, I would, even if they said to me the whistleblower information wasn't good enough, that would be fine. I just haven't had a response. And then my biggest example in my other period was around Google, because when we did the public hearings around Google's behavior and not paying a tax, and their claim that they were not undertaking economic activity here in the UK, I can't tell you how much I got from whistleblowers saying that they had been they had lied in effect about where their economic activity was taking place. And again, tons of stuff I gave to the authorities. It never came back. I never got an answer back. So we need those structures within our government, but we also need them to act. And it's partly about resourcing, but it's partly about a political will to respond. The final thing I want to say about whistleblowing is that I'm all for modernising the legislative framework, and clearly, with thanks to Protect and Leigh Day for putting on today's event, that is important. But I just want to make an observation, which really Jonathan's contribution showed. Whistleblowing is horrible. It's really, really hard for the individual involved. And when we tried at the Public Accounts Committee to have a session just examining whistleblowing, in a sense, it wasn't a very satisfactory session, because we could only find one of the many, many whistleblowers who had come to us who was willing to give public evidence about their experience of whistleblowing. And it isn't just a question of getting the law right and getting the protection in law right. It's actually what happens in the work environment to the whistleblower after they have blown that whistle. And it just becomes and I don't know how we can deal with this. I've thought about it a lot. Maybe you've got better ideas. I don't know how we can better protect whistleblowers to carry on. I mean, as Jonathan said, will he ever get a job again in his speciality, for which he's got both the qualifications and the experience? And it's really hard. And my greatest regret on that is that is the man who worked for HMRC, who started us on this whole journey of investigating tax avoidance, evasion, and then illicit financial crime. He was a lawyer who worked for HMRC. He gave us the evidence which demonstrated that HMRC had entered into a sweetheart deal with Goldman Sachs, who was the first people that we investigated in the Public Accounts Committee. Time and time again, I mean, when it all emerged, his computer was hacked, his wife's telephone was hacked, his marriage broke down. And time and time again, I would say to the head of HMRC when she gave evidence to us, are you protecting the whistleblower? And she always gave me reassurances that she was, but life was made so intolerable for the individual that in the end, he had to leave, he had to retrain, and his life also, like Jonathan's, was destroyed in many, many ways by the experience of whistleblowing. And how we get a culture in our society that respects and actually thanks whistleblowers for the job they do, I think is an enormous challenge that we all face.
Thank you very much indeed, Margaret. That was a wonderful overview of the very many different prongs that we need to better protect whistleblowers, and that's a challenge we can throw out to the audience later about, what do we need to do to change the cultures in our organisation? Because as you say, it's not just legislation. A huge amount of that is the culture. But maybe there's something as well in the regulators that we can come back to as well about, they don't have a duty of care. They don't have any responsibilities at the moment towards whistleblowers. And it's very frustrating for whistleblowers and for you, obviously, when you throw your information in there and then hear nothing further. So maybe that's something we can pick up as well in the conversations afterwards. Thank you so much. I'll turn now to Paul, and who's going to give us an overview about the very interesting, for all the lawyers in the audience, and I know there's quite a lot of them. It's a really interesting case, and it's broken new ground in terms of whistleblowing. So over to you, Paul.
Thanks, Liz. So, I'm just going to talk briefly about this, the case of Amjad Rehan that Liz alluded to before, and just outline some of the wider implications that I see coming out of that case in terms of legal protections for workers who become embroiled in corruption overseas through no fault of their own. So Mr. Rehan's case concerned allegations that EY, he was a former partner or a partner at the time at EY, and he claimed that EY had covered up the adverse findings of a sustainability audit into a Dubai gold refiner, including evidence of money laundering and conflict minerals. He ended up resigning, fleeing Dubai, so during the course of the audit, he and his team had uncovered serious money laundering red flags, so billions of dollars worth of cash transactions, gold bars being imported from Morocco, which had been painted with silver to avoid restrictions on exports of gold from Morocco. He came under pressure from both the gold refiner and the Dubai regulator, which is an organ of the Dubai government, to water down the findings of the audit report, try and brush it under the carpet. The regulator, the Dubai authorities were keen to protect the gold industry in Dubai, which is big business there. So Mr. Rehan escalated his concerns about the pressure he was coming under to EY's senior executives in London, but instead of supporting him in resisting the pressure he was getting in Dubai from the regulator and the audit client, they proceeded to engineer an approach whereby the damaging findings would never see the light of day. Meanwhile, he and his family fled Dubai in fear of their safety, because he was now left sort of isolated, hadn't received any institutional support from EY. He was left isolated there in his position in opposition to the approach that was being taken by the Dubai authorities. He came to the UK, left EY, went public with his allegations. And then after being publicly identified as a whistleblower, what Jonathan was saying certainly rings true with Amjad Rehan, in that he was never able to secure alternative employment in that industry again. His career was completely destroyed. So three years of contentious legal proceedings later, the case went to trial in February 2020, and in April 2020 the court handed down its judgment, and it found in favour of Mr. Rehan. It found that senior EY global executives had consistently acted in breach of their professional and ethical standards when dealing with his concerns, including presenting misleading audit reports. By way of example, the court found that EY had amended the gold refiner's reference to silver-coated gold bars in its audit report describing it instead as documentary irregularities. The court found that by colluding with the Dubai regulator in its efforts to conceal the damaging audit findings, EY had breached its duties of integrity, objectivity and professional behaviour, and it awarded Mr. Rehan $10.8 million in damages. EY appealed, but then withdrew that appeal in December 2020, and so the case ended then, and Mr. Rehan definitively won. So in terms of the wider implications of this for whistleblowers, the court created an important new duty to ensure that individuals working in an overseas context, so overseas operations of UK companies, that a duty not to embroil them in unethical conduct, which means that whistleblowers who are working for multinational organisations may be able to obtain substantial compensation even when they fall outside of the scope of the Employment Rights Act, which doesn't protect currently overseas workers. So it's closed that an important gap there in the law, particularly because it's in overseas environments where workers may end up coming or being exposed to the most acute risks of being embroiled in unethical conduct. They may be in a place where there's weak local regulation or simply a tolerance of conduct that's not acceptable by UK regulatory or legal standards. And secondly, connected to that first point, it's now clear that as far as English law is concerned, English professional conduct regulations trump the rules or directives of a foreign regulator. So EY had consistently tried to argue that all they needed to do was follow what they were being told by the regulator in Dubai. Well, the court said, no, that's not sufficient. You have to comply with your own professional standards where there's a conflict. Thirdly, the Rehan case was unique because it was not brought against the claimant's employer, not brought against Mr. Rehan's direct employer in Dubai, but against these UK-based governing entities of EY, so it raised this important legal issue as to whether those entities could be liable to him where they weren't his actual employer, and the High Court found that that they could on the basis that they'd assumed control over the whole issue and interacted with Mr. Rehan to a major extent. So that was an important development as well. Just finally, which is an issue that perhaps we can touch on later, which is one that Jonathan raised as well, which is this point about legal costs. Bringing the case in this way outside of the employment tribunal regime did enable Mr. Rehan to fund his case via a conditional fee agreement, so a no-win, no-fee agreement, which meant that he could get funding for his legal costs as the case went along. That's not available in the employment tribunal currently. Litigants have to fund their own legal costs. I mean, we can, as I say, come on to it later, but that is a big issue in my view, is the fact that you get the employment tribunal, there is no funding for legal costs. You get lots of litigants who end up just having to represent themselves against major corporations, and that is the most fundamental issue I feel that needs to be addressed in terms of getting access to justice for whistleblowers. So yeah, I'll leave it there.
Thank you very much for explaining it to us, and I think I do hope we can pick that hurdle up. The huge imbalance of powers that we've heard in Amjad's case, in Jonathan's case, and indeed in many whistleblowing cases. It's the individual against the company, the multinational, and the resources that each have are just so unfair. But I'm going to turn now to Andy and give you the really tricky job, Andy, of trying to summarise some of what we've heard today with what Protect thinks and synthesise that beautifully, as I know you can, to tell us a little bit about what you think we should be doing and pulling together some of those themes that we've had today.
Yeah. So yes. Yeah. Hello, everybody. So I'm going to try and answer Jonathan's question about the Taylor test, which I think it's a good way to think of it. But I do think there are two types of whistleblowers that I want to try and address. So the first isn't going to pass the Taylor test, but is important. It's those individuals that spot corruption or fraud in the workplace. They want to raise it with their employer. I think all whistleblowers want to do that, but it's not a case of working for an employer that Jonathan was working for that was corrupt really in terms of its business model or from top to bottom in terms of an organisation. And so in that situation, I think it is a case that the legal framework is useful to think about in terms of, as John Penrose said, like how do you make the Public Interest Disclosure Act, which protects whistleblowers for the Employment Tribunal, much more cutting edge. And I'd say one of those areas is duties on employers. So the ability to have something in place that says, well, employers will have these standards that they will be held to account via regulation or via sort of laws to so that those whistleblowers coming forward with concerns can be reassured that things like confidentiality, feedback, the concerns being looked into going to be all sort of covered by that law. So I think that's really important. But I think the other side, which has always been part of whistleblowing, I think from when the law was passed in 1998, is the idea that whistleblowing cannot work unless there's external routes. So the ability to go to the media, the ability to go to regulators. And that's a key point, which is the idea that you need effective regulators. And so standards on regulators in terms of, as Margaret was saying, feedback, that's a massive issue. Whistleblowers really hear nothing when they go to most regulators, even regulators like the Financial Conduct Authority that have sort of whistleblowing arrangements that they force banks to have. They give very little feedback to the whistleblower in terms of what's happening with their concerns, and that's a key issue. But also I think there are resource issues as well. Lots of regulators, especially in this case, in the situation of anti-corruption, are underfunded. So Spotlight on Corruption found that the National Crime Agency's budget decreased by 4.2%, and also the Crown Prosecution Service saw their budget cut by 33%. So I think one of the things that I struggle maybe as head of policy at Protect to answer, because I'm not necessarily expert in different kind of areas of legal enforcement, is you could have a really effective maybe ability to approach a regulator in terms of passing information on, but what happens to those concerns when they are passed on? And that's a key sort of issue. But I think to turn to Jonathan, the Taylor test for any legal reform, what I would say is that slaps are used to really, not to really get to court. The idea is not to bring the whistleblower to court, it's to kind of drive them down into the dirt. And I think, I do probably think actually more a wider sort of civil defence shield or public interest defence within sort of civil law and criminal law would really help, because I think it would make lawyers think twice. You would have an architecture you could cling to, and we're seeing this in the EU directive. There is a civil litigation shield there. But I think the other thing, and I'm going to stop in a minute because we're going to take questions, but I think the other thing is access to justice. There's such a disparity of arms. It's getting probably worse, I think. It's not getting better in terms of companies having the ability to hire lawyers. I know from working on Jonathan's case, more from the parliamentary end, but I know that civil society picked up the bill to help Jonathan when he was stranded in Croatia, fighting that extradition case, or it was lawyers like Toby Cadman doing basically work on pro bono. And that doesn't feel right to me when the level of fines that Jonathan sort of brought forward, that there isn't a way for those law enforcement bodies to, as Liz said, have a duty of care towards a whistleblower beyond maybe their own kind of infrastructure or their own processes in how they handle those concerns, which I think is really important. But I think at the end of the day, you need the ability for regulators. Well, do you need regulators to see a role in helping defend or fund those type of legal actions when it's outside of the employment tribunal or outside of labour laws? Because you just undermine every single whistleblowing protection if employers can reach into different forums to pursue a whistleblower.
Yes, and that's a very sombre note to end on. But I hope we've given everybody a really broad overview of the challenges ranging from the culture inside organisations and across society, the regulation and the lack or thereof of enforcement. The Taylor test is one that we'll come back to, and how do we properly protect whistleblowers and give them access to some better equality of arms. But I'm going to turn now to the audience, and thank you very much for listening. And any questions that you'd like to put to the panel? Yes, please. Do you want to say who you are? Yeah.
My name's Dennis O'Connor. I'm a recovering banking compliance officer. And through my career, one case I developed, I saw some corruption go through my bank. A customer, a foreign customer, work it up to an SAR, submit the SAR. Eventually, civil servants and politicians abroad got banged up. But the corruption was instigated by a French multinational. It took the French authorities 10 years to find the multinational. But my question is, if there's any American lawyers in here today, they would point to the US system of statutory reward reimbursement, the SEC, DOJ, those sorts of people paying substantial sums, like tens of millions of dollars, to whistleblowers in a case of a prosecution. That doesn't seem to be the flavour or in favour in this country. Do members of the panel think we should have a US-style reimbursement system?
Thank you. That's a really good question. Shall we put that to John Penrose first? What do you think? Should we change the system of how we effectively compensate whistleblowers for the very, the life-changing losses that they have? Is the employment tribunal the best way, the only way, or should we look to rewards?
So I'm sort of torn between two opposing factors here. One is I'd be worried that we'd be creating moral hazard for someone to try and if they've got a personal reward incentive to big up their evidence, that's clearly not something which we want for any kind of case, whistleblower driven or not. So we would need to be careful to avoid moral hazard. I'm not saying it can't be avoided, but we would need to worry about that and be careful. But I'm completely on side with the notion that if not this, then something needs to be in place so that people like Jonathan Taylor or any other whistleblower who gets completely monstered, so they can't work again in their chosen sector, that they actually have some way of paying the gas bill for in future as well. And the Jonathan's example, I'm afraid it was heart-wrenching to listen to, but it is far from unique. That's the problem. So we need to find some way of making sure that people know that the personal consequences for them will be survivable. And some of them are emotional, but some of them are financial. So if not this, then something better than where we are at the moment is clearly necessary.
Thank you for that. And of course, the Employment Tribunal here, we have uncapped damages, but that does require you to be able to bring a claim in the UK, and both Jonathan and Amjad were not in that position, and to succeed in a very difficult climate. But Margaret, do you have a view on whether rewards is the way forward for whistleblowers? Do we need that here?
My only reluctance is this issue that I don't think the state should pick up the tab on it. And if you're whistleblowing against an organisation that has, we've all discussed today, big organisations. These are not insubstantial corporations that can afford it. I think it should fall to them rather than the state. And I just make a plea to you, because I think that we're sitting here in a law. Well, you're sitting in a law firm, and it always seems easiest to talk about financial compensation and legal trying to find legal ways in which to find an answer. But I don't think that deals with this issue. With Jonathan's big issue, if it's going to pass the Taylor test. What happens to Jonathan next year? So on the money, I would be reluctant for the state to pick up the tab, if I'm honest.
Can I come back on that? Because I think Margaret's absolutely right about this shouldn't be the taxpayer having to fund it. But also, if you can make sure that it's clear who has to pay the damages to the whistleblower, and it's the person they're whistleblowing against, you can also then, I think, start to envisage a system in future which might build in a really bigger incentive to the employer to not monster the whistleblower in the way that routinely happens at the moment. Because if they know that if they monster the whistleblower and the damage that they inflict is so terrible that they are the people on the hook for putting that damage right financially, they might actually start to say, hang on a second, let's try and minimize that damage. Let's try and not monster them quite so severely up front. That might be one of the things that gets them to think again and think early rather than when it's too late.
Absolutely.
A point of information, the system in the States only kicks in when the authorities have levied a penalty on the company. So the taxpayer does not pick it up. It's a diversion.
Comes out of the fine.
It's a diversion of the fine.
Right. Thank you for that clarification. I don't know if Jonathan or Paul want to pick up on either of this question. Do you have a burning response on this, or?
So I was actually going to mention exactly what the questioner rose. Of course, the idea of these fines, any percentage the whistleblower does get comes out of the fines as opposed to the state. Personally, I would just look at something just far more basic than that, just support. I was going in and out of the offices of the Serious Fraud Office, helping the SFO in relation to details of Rolls-Royce corruption. So SBM, my former employer, used the same Brazilian agent to pay bribes. I was helping them when the then Home Secretary, someone called Theresa May, gave leave for the Brazilian investigators to have an extraterritorial investigation in the UK. So I attended their offices to speak with the Brazilians. I helped them with the Unit case. I did everything and anything I could. There was new information I came up with just before my exile in Croatia. I got not one gram of help from the British government. I'd gone out of my way to do all I could to assist the SFO in every possible way. Every time they called up, I went round. They came to see me occasionally, and I was wrung dry, if you will, for information. But when push came to shove, I was hung out to dry, no assistance whatsoever. So yes, financial assistance would help, but way beyond that, just practical assistance, just standing up for me, representing my issues at a governmental level would have been nice.
Right. Thank you. And I think that's a very good question that John Penrose poses. If not rewards, then is there a better solution? Andy, do you want to sort of set out what we think of protect around rewards?
I think I'll probably just say on rewards, one of the reasons we don't support them at Protect is if you look at the US, they in fact help a very small number of people. So the idea in the US is it's quite novel information that comes forward. So it's usually the one person that gets that slice of the fine. So there are lots of criticisms about the UK approach, but the Public Interest Disclosure Act carries across multiple sectors, multiple industries. And part of that is also, I think, something to bear in mind is that whistleblowing in the UK is quite much wider as well. Fines are not issued in safeguarding cases or health cases with clinical kind of malpractice. So I think there are two different systems, and there's a danger, I think, in this debate sometimes that you can compare apples with oranges. But to answer the actual question, which is, if not what instead, I think it is a case of legal aid or a fund from fines that can be used to support the whistleblower, because I don't think it is just about money. It is also about support, and I agree with Jonathan completely in the sense that it was completely, when we were campaigning to try and get Jonathan from extradition, it was even hard to get the British government to acknowledge that he was even a whistleblower. So it's like, I feel like the regulators can do so much more in terms of what they say, how they interact with the whistleblower to give that sort of practical support, because it's sorely lacking when it gets to that point.
Liz, just to come in on that, I think that's an area where we could put duties on the regulators. I mean, the FCO was appalling in Jonathan's case. They did everything they could do to avoid getting involved, really, rather than accepting responsibility for a British citizen who was stranded abroad because he'd been a whistleblower. It's extraordinary. So I think, and maybe John would sort of support that with me, but I think the idea of putting duty, and the same is true of HMRC, the same is true of the NCA, all these organisations where whistleblowers will tend to, or the SFO, all these organisations where whistleblowers will tend to go, ought to have duties on them, and that might have helped my man in HMRC, who then got also had to leave his job in the end.
Great.
I mean, I think that's not a bad idea.
Yeah. Thank you. Well, we'll be certainly lobbying you in due course for all of these changes. Another question. I've got one here, and then maybe the gentleman at the back. So, Ian, do you want to introduce yourself and ask your question?
Thank you very much, Elizabeth. My name's Ian Foxley. I'm the CEO of an organisation called Parhesia, who looks to influence policymakers in order to change the law to better protect whistleblowers. I'm also the whistleblower behind the Airbus scandal and GPT that took 10 years, 11 years to bring to court and resulted in a fine for, well, a DPA for Airbus that resulted in 3.6 billion and £30 million fine for the subsidiary GPT involved in corruption in Saudi Arabia. So everything that John has spoken about and been through, been there, done that, and I empathise greatly with you, sir. My observation is that this is about what, when, and how. The what is how do we counter the two fears that Elizabeth raises, which are the primary reasons why people do not speak up. First is fear for home, health, work and wealth, and everything that Jonathan raised falls into those four categories. And secondly, how do we make them more effective? How do we make sure that when people do stand up and speak up, they actually get a result? It's not just a voice crying in the wilderness. So the counters to those, I think effectively is very simple. It's making the regulators regulate and forcing them to do it. And if they won't do it themselves, then set up an independent body that will hold them to account and gives whistleblowers an alternative access to somebody who has the power to give them a voice and make them effective, a commissioner or an officer of the whistleblower, whatever you want to call it. And secondly, we take sanctions against anybody who takes reprisals against that whistleblower who has stood up and spoken up. And that needs legislation. That needs a statutory act to give that independent body the ability to fine or to disqualify individuals, because it's not just the organisation, it's the individuals within that organisation who affect the mechanisms of the organisation to protect itself against the individual and what he's trying to say. And that brings me to the last point and the real question, which is when. And I find it, I'm sorry, John, but I find, John Penrose, I find it rather dispiriting to hear that there is no set timetable for this. I thought that the year 3 report on your first strategy was I'm sorry, but you failed slightly. You as an organisation in the Home Office, JACU, failed with not pushing the whistleblowing agenda and the measures that you put at priority 3. And that does need rectification. And we've spoken about this and you know that, and I hope it does feature in the next strategy. But it needs more than that. It needs to hang on a piece of legislation. And we started this evening talking about Ukraine and what's going on. We as a country and we as NATO are not going to take on Russia physically. We are not going to get into World War III. Therefore, we have to find another way. Another way is the economic way. Bring about the economic pain, bring the change from within Russia by closing down all those corrupt people who are burying money in our society. And we have an ideal platform now to hang whistleblowing protective measures who are at the back of revealing where this money is and how it happens on the back of an economic crime bill. And I think that is exactly what Parliament should be doing now, is putting its foot down and saying this is absolutely key to where we go as a country and where we, Europe, stand up to the bullies in the world. So my question is, when and how are you going to do that?
Thank you very much, Ian. And I'll ask, I think we'll just ask Margaret and John if they've got any answer on the time frames here. It's a tricky one, but and I think John, you've kind of given us your answer already. But if you just want to come back to Ian there,
just very shortly, because you're right. I mentioned this in my opening comments. Look, no argument that we are behind. I said it right at the start. I'm not happy with it, and we need to press ahead. And I think there are two things we need to do. One is to actually just implement what we've already got much more thoroughly and do much better enforcement and much more delivery. But also we will need some, and we can make an awful lot of progress with that even before we get on to extra updating legal powers, but those are also necessary. Listen, I'd love to see updated whistleblowing powers in the Economic Crime Bill. My only concern is a practical one, which is I think it's already going to turn into a pretty big bill. And if I had to choose, and I hope I don't have to, but if I do have to choose between extra whistleblowing powers in the Economic Crime Bill or the upgrades to Companies House, then the upgrades to Companies House are even more urgent, even though the whistleblowing powers are absolutely vital too. I hope I can have my cake and eat it. I hope we can have both. I'm sure Margaret and I both want that. But that's the urgency about it, and that's what we've got to get done.
Thank you. Margaret, do you agree with John? Is there or is there a possibility that we could still get some whistleblowing even within the huge economic crime bill that we're expecting?
Well, the only thing I would say to John, having been around forever, you can't miss the opportunity of the economic crime bill. So I'm really happy to I hope working with John, but certainly working with you as sort of interested parties to pursue the whistleblowing clause in that. They'll then, the way government works, this is our one opportunity. And if we lose this one, you won't get a whistleblowing bill, I bet you, for another 3, 4, 5 years, because they'll say, well, we did all this economic crime. We've got other things we want to do. And I mean, I don't know, John, whether you said this at the beginning, but God knows, I'm losing track of time. A month ago, we weren't going to have an economic crime bill. When Lord Agnew resigned, one of the reasons for his resignation was that they dropped it, much to all our horror. So I think thanks actually to John and others on the Conservative benches, it's now been reinstated. Sadly, on the back of this, the Ukraine crisis, it's getting prioritised. But I would just urge you, John, we won't get another opportunity, so we've got to do it now, or it'll just fall into the long grass.
You're preaching to the choir. I just want to, just the problem with it will be that the Companies House stuff will inevitably rank higher. But if we can get both in, we should.
Thank you. That's really wonderful news, and we'll do everything we can. And I know we'll work with Ian as well to make sure we give you some possible amendments there. I'm going to take one more question because I know we're running over, and we have some drinks afterwards. So I hope you'll all be able to carry on the discussions after. Have you got one quick question at the back here?
Sorry, I'm just standing up so that people in the front can see me. My name is Franz Wild. I'm with the Bureau of Investigative Journalism. Just two quick questions, in fact, because we've got so little time. The first one is, obviously, I think most of the whistleblowers not only experience sort of slap suits, but also all sorts of other attacks. Do you see any scope for that being included in any kind of legislation? I mean, I know the type of attacks, kind of surveillance, hacking, eavesdropping, it's fairly amorphous, but is there scope for including that in some way? And secondly, I mean, you've sort of touched on this, but I've been following this issue for about 8 years, or 6 years rather, sorry, and the debate's kind of been the same. And I know it's sort of going to be in the economic crime bill, but why has it actually taken this long? Because it doesn't seem to be an issue that's particularly contentious.
I think that's a really good point, and we can see here with John and Margaret both, from opposite sides of the political spectrum. But it's not a party political issue. It's an absolutely, if you get whistleblowing, you get how important it is. And I think that's a really good question. On the slaps issue, I mean, we're part of a consortium of organisations that are pushing the slaps issue hard. I don't know if anybody wants to comment on that. Is countering the strategic litigation argument, is that something that there'll be any appetite in Parliament for? Margaret, perhaps I'll come to you first.
Well, the interesting thing on the slaps issue, sadly, I had COVID, but David Davis, who is another Conservative, led, a very powerful adjournment debate. I don't know if John got in on it. I wasn't around that day, but on the slaps issue. So there is, again, cross-party consensus. Let me just say this. I don't know whether I said my opening remarks or not. I think in the backbenches, there is greater unanimity than there is with the government. And I think the problem with all this stuff with the government is there's this real fear, dare I say it, post-Brexit, when the economy's been sort of hit, you've got 2% reduction in the economy as a result of Brexit. There's a fear of taking on the very powerful financial services sector and all the associated sectors with it, which are now, are a much more important part of our economy. And every time, I hope John agrees with this, every time you think you got agreement around one of these anti-corruption measures, you then find some of these financial institutions or the lawyers, I'm afraid lawyers as well, or the accountants going in and banging the drum on the other side. And it's really, and I think government is very, very fearful of challenging their power.
Well, I'll give the last word to you then, John, because as the challenger of the government in your anti-corruption role, do you think that there, is there a movement, is there a feeling in government as well as among the backbenches that these are issues that are important and urgent and need addressing now? Or what more can we do to help you explain those that it isn't just something that you can be pushed aside by the lobbies?
I've never heard anybody objecting in principle and saying this or that anti-corruption measure is the wrong thing to do, and whether it's the Companies House reform stuff we've just been talking about, or indeed whistleblowing measures. So I've never heard anybody turning around saying, we don't think this is sensible in principle. It's much more common, I find, that the problem, and we've had Brexit and then we had the pandemic. It's much more problem just to say, look, there are a whole load of other things which are even more urgent and they're blotting out the sun, and therefore we've got to do this or that instead. So I think it's a problem of, sad to say, political sexiness or lack of it. And this is important. We all understand the importance of it and the urgency of it. But the difficulty is, compared to all the other stuff where there's a burning platform over there and over there and over there on other issues too, we've got pushed backwards down lists of priorities. And that's why I think, I don't know, but I'm guessing that's why Lord Agnew saw that the economic crime bill was dropped in a couple of weeks ago from the next Queen's speech, and why we all had to jump up and down and with our hair on fire to get the thing reinstated. I think that's the problem. And I think that we need, so Margaret is right, we won't get enough opportunities. We need to grab whichever ones we can and shoehorn as much as we can into this when the opportunity presents itself. But I don't think it's a problem of closet opposition in principle. I think it's a problem of bandwidth and of urgency and of, dare I say it, political sexiness.
Well, that's a challenge back to us then. We've got to make this issue politically sexy and a burning platform, and that's our challenge for Protect. And we're going to carry on campaigning, and we'll be lobbying John, Margaret, and other MPs as well. I wonder if the audience here could just thank our esteemed guests on the screen over there for their contributions. It's been a really interesting debate. So shall we just give John, Margaret, and Jonathan and Paul for his wonderful contribution, and thank you to Andy too. Can we give everybody a round of applause?